Good morning, ladies and gentlemen. I trust that you are all well. So yesterday I had like double load shedding. So at the time that I said I was going to record this session and upload it for you, it turned out to be impossible because by the time that I woke up, I only had to do a few things before they had to take the power again. So as I said previously on our meeting, that we're going to discuss status. So I will start from here. I know we have discussed status previously. So sorry again, I didn't finish with my slides. So I'm just going to work from my notes. And then once I'm done with my slides, then I can share them with you guys. So as I said, that today we're going to discuss status. We have spoken about this before. You will know that status is derived from a Latin word, stare, which means standing. In a juridical sense, status refers to a legal subject standing in the legal world. That is the position of the legal subject in the legal world, or the role that a person plays in legal intercourse, or basically the functions of the person in his or her capacity as a legal subject. So before we go on, just a refresher, and then I'll give you an example as well. It is very important to understand that a legal subjectivity and status are closely connected to private law. You will remember this from our previous sessions. So while every legal subject has legal subjectivity, a person's status determines whether or not, as well as the way in which he or she can participate in legal intercourse and the extent to which he or she can participate. So a simple example that I can give to you guys today is that if Peter is a one-year-old child, and we know that he already is a legal subject and has legal subjectivity. So now the question which arises is whether or not he can participate in legal intercourse in the same way and the same extent which an adult would. So for example, yes, he can conclude a legal contract because he is a legal subject. However, it is evident that he can indeed conclude that contract, but he is going to need some assistance, which will be in the form of a parent or a guardian who can conclude that particular contract on his behalf. He cannot conclude it by himself because he does not understand the terms of the contract. So he will need an adult or a major, a parent or a guardian to conclude that contract on his behalf. In this way, he can participate in legal intercourse, and in legal terminology, it is said that an organ must act for Peter and on behalf of Peter. So capacity as a core concept of status, because we have repeatedly pointed out that status is related to the participation of a legal subject in legal intercourse. This simply means that a legal subject has juridical ability to take part in legal intercourse. A synonym in this case for juridical ability in this context, it's capacity. So the word capacity indicates that a legal subject can participate in legal intercourse, for example, by concluding a contract, entering into a marriage, or drawing up a will. So the nature and the extent of a person's capacities, they depend on a variety of factors. If you can recall from our previous session, these factors can include age, domicile, extramarital birth, which will be dealt with in the next sessions that we're going to cover. So from the example of a one-year-old child, one-year-old Peter that wants to conclude a contract, it's evident that a person's status can be limited, and the child, which is Peter in this example, cannot participate in legal intercourse as an adult. So no person can be without any juridical capacities, but to qualify as a legal subject, there are three legal capacities that are essential. So these legal capacities first is the legal capacity, the capacity to act, and the capacity to litigate. Legal capacity is the capacity to be a legal subject, and the capacity to act and the capacity to litigate deal with the capacity to perform a juridical act. Let me repeat that. To qualify as a legal subject, the three legal capacities are essential. It's the legal capacity, capacity to act, and capacity to litigate. Legal capacity is the capacity to be a legal subject, and capacity to act and capacity to litigate deal with the capacity to perform a juridical act. So now let's start with the legal capacity. The legal capacity, which is the capacity to participate in legal intercourse as a subject, is referred to as legal capacity. And legal capacity includes the capacity to hold offices as a legal subject. For example, to be a spouse, to be a testator, that will mean to be able to draw a will, to be a contracting party in a contract, to be an owner of a company or a company director, and to have the rights and obligations which result from holding such office. So all persons have legal capacity, but it is evident that a person's legal capacity can be limited. So we have discussed this previously. A person under the age of puberty cannot hold the office of spouse. A person under the age of 16 cannot hold the office of a testator because statutory provisions make it clear that a person must be at least 16 years old to draw up a legally valid will. So most of these things you will see that they're interconnected to our previous sessions. And you'll see that we have spoken about age previously. We're still going to talk about age because when we're talking about, we cannot talk about status and capacity without talking about age. So the capacity to act. The capacity to act relates to the capacity to enter into a legal transaction, where in the case of legal capacity, the issue relates to what a person legally is and can be. Capacity to act relates to the capacity of a legal subject to perform in legal intercourse. It is more specifically deals with the capacity of a legal subject to conclude juridical relevant acts. It's already at this stage important to understand that such an act is one that involves voluntary performance by the person performing the act. So you cannot take an infant and you say they are performing a contract voluntarily. They do not understand the terms of the contract, so they need to be assisted, which an adult or a parent can conclude that contract on behalf of the infant. So the exposition of a legal act can be explained as follows. So if A concludes a contract with B to buy his bicycle for 200 Rand, this is a voluntary act by A and B, which is also legal because it complies with the law in respect of contracts. Because the law is interested in giving effect to that which A and B want to do, it must be asked whether the agreement between A and B constitutes a legal act. A legal act is an act to which the law attaches the same consequences as those which the acting persons A and B wanted to attach to the act. A and B intended for ownership of the bicycle and the money to be transferred to each other, and the fact that their act is in fact a legal act means that the law will attach the same consequences thereto, the transfer of ownership as intended by both parties. So I hope that you do understand the first concept that I explained to you guys. If you do have any questions, you can just type them in the chat box below, and then I will get back to you. So this is a very short, it's a very short topic, status that we're going to cover today. The next part we're going to cover is the capacity to litigate. So a further way in which a legal subject can participate in legal intercourse is as a litigant in private law actions. So capacity to litigate is defined as that legal competency which enables a person to act as a plaintiff, a defendant, an applicant, or a respondent in a private lawsuit. The Latin term locus standi in judicio is typically used to refer to a person's capacity to litigate. Just as in the case of a capacity to act, we can distinguish between lack of capacity to litigate alone, limited capacity, which in this case, previously we referred to the minors, and full capacity to litigate. A person in the first category, typically an infant, cannot sue or be sued in his or her own name. A person in the second category, which in this case we refer to a minor, can sue or be sued or can be sued, but he or she requires the assistance of his or her parent, guardian, or the parent or the guardian can litigate on behalf of the minor. And on the last category, we referred to a major, which is a person of 18 years and above, that generally falls into the third category, and they have full capacity to litigate unless mental incapacity affects his or her status. So, like I said previously, I do not have the prescribed textbook that you guys are using. I am using Introduction to South African Law of Persons. If you need some screenshots, I can do that for you so that you can see where I am working from. But your textbook is perfectly fine. We all have the same information. So moving on to the capacity to be held accountable for crimes and dealings. So the three capacities that we dealt with previously, they do not include a person's capacity to be held accountable for crimes or dealings which the person he or she commits. And then some will say that the capacity to be held accountable can be seen as the fourth capacity, which is neither correct or incorrect. So the capacity to be held accountable is commonly known as accountability. Accountability is to a large extent influenced by a person's age and mental condition, because fault in the form of intent, in this case we refer to it as dollars, and negligence culpa is a requirement for both criminal and intellectual liability. So the test for accountability in criminal law can be referred to as criminal capacity, capacity for fault, or capacity for negligence. But in this case, we'll refer to it as accountability. It is very necessary that the mental capacity for a person to be put into consideration when dealing with accountability, because we also want to see if the person can be able to appreciate the difference between right and wrong, and in accordance with that appreciation. So the last part of this section, we're going to deal with curatorship. So you will see, according to our previous discussion as well, we did talk about the curators, but we didn't go into detail. So now we're going to go into detail with regards to curatorship. In terms of the Rule 57 of the High Court rules, an application may be brought before that court for the appointment of a curator. The court will then make such an appointment if it is of the opinion that the person on whose behalf the application is made is unable to manage his or her own affairs. The reason for the inability to manage his own affairs is usually related to mental incapacity, but may also be due to some psychological or physical defect. The primary purpose of the appointment of a curator is to take care of the property of the person under curatorship, but sometimes also to take care of the said person's personal and health-related matters. So the first one we're going to look at is the curator bonus, which according to our last discussion, it was the curator bonus is appointed to manage a person's proprietary interest. And we have a curator persona who is appointed to take care of the person's personal needs in question. So normally the courts are usually reluctant to appoint curator persona due to the significant infringement on the freedom of the person of which the curator is appointed. In this case, you will have to look at the example of, I think it was Britney Spears, the American musician, when her father was appointed as her curator. She had a lot of problems regarding her freedom. You can look at that on your own. I am not going to dive deeper on that. You can just go and read on that, and then you can do the comparison yourself. And then the third category of curatorship is called the curator ad litem, who is appointed to assist a person in the legal proceedings. So before I end off on today's session, we'll look at the requirements for the appointment of a curator. So in order to persuade a court that the appointment of a curator is essential, the fact that the person in question suffers from a mental or physical disorder, making it impossible for him to manage his or her own affairs, should be made known effectively. So there needs to be evidence, and this evidence should be in a form of an affidavit, at least by one person to whom the person on behalf of whom the application is made. And in that affidavit, there must be a description of the person's mental state, and at least two affidavits by two medical practitioners, and one of them should be a neurologist or a psychiatrist who have recently examined that particular person, and the report must contain information on the nature and the extent and probably the duration of the mental incapacity. And based on those, the court will then decide whether the relevant person is capable of managing his or her own affairs by considering the facts of each individual case. And lastly, I will discuss the duties. I'll just list them for you. I will put them on the chat box for you. The duties of a curator. So a curator's duties may be summarized as follows. They can manage the affairs of the person under the curatorship in a caring and careful manner. They provide security for the proper fulfillment of his duties unless the court releases the curator of his duty. In case of a curator bonus, to lodge an inventory to the master of the High Court containing a setting out of all the property of the person under curatorship under control of the curator. To avoid any conflict between his curators on affairs and those of the person under curatorship. To assist the person under curatorship in legal proceedings. That to be the curator ad litem, as we referred to it previously. To provide an annual report regarding the administration of the relevant estate to the master of the High Court. A curator is entitled to remuneration. So if you appointed a curator, you must show that you must know that you're not going to be working for free. So you are entitled to the remuneration for the services that you are providing from the income generated from the property under his curatorship. And the court also may also determine a specific amount of remuneration. And lastly, the termination of curatorship. Curatorship will be terminated in the following circumstances. If the person under the curatorship dies, if the court terminates the curatorship, for example, if the person under curatorship regains their mental health, if the curator itself dies, if the period for which the curator was appointed lapses, or the task for which he has been appointed is fulfilled, if the curator resigns or is relieved from his position as such, and lastly, if the curator is relieved from his position as such by the High Court or the master of the High Court. Ladies and gentlemen, this brings us to the end of today's session. In our next session, we're going to discuss domicile as a factor which influences status. So I will ask you to use your prescribed material and read on domicile, draft any questions that you might have, and then you can send them to me by email, or you can simply type your messages on the chat box. I will also notify you when the next recording will be up. Thank you very much for listening, and I will see you on our next session, which will possibly be live if we are not affected by load shedding. But you are welcome to send me any questions that you have, and goodbye for today.